Judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in it for the State of New York, may now draw near, give their attendance, and they will be heard.
Welcome to Court of Appeals Hall. We're delighted to have you. We're going to start with number 156. You look like you're ready to go, counsel. Would you like any rebuttal time?
Not necessary, Judge Lippman.
No rebuttal time. Okay, great. Proceed.
Thank you, Your Honors. Good afternoon, Your Honors. I'm Jack Dweck from the Dweck Law Firm, and we represent the plaintiff, Georgitsi Realty. You have before you two questions that have been certified from the Second Circuit Court of Appeals. We have a damage case that resulted in a denial of coverage by the...
What is vandalism all about in this policy? What do you have to show to recover on a policy that has vandalism coverage for willful and malicious damage to property?
Judge Lippman,
yeah.
You're right on with that question because you need to show either intentional conduct or conduct that is so reckless and wanton as to constitute the equivalent of intentional conduct.
How do you define the latter? What has to happen to have something that's so, over the edge that it's the equivalent of intentional?
You mean egregious?
Egregious. Okay. Stand amended. Go ahead.
One of the associates in my office referred to it as "I don't give a damn" conduct. In our particular instance,
yes. Tell us why in this case is "I don't give a damn" conduct.
We have an adjacent owner that was excavating to 60 feet below the surface. They did not properly shore up the building, and my lady who owns the apartment building has sustained severe damage because the building has become unstable.
Well, there were stop work orders, right?
I'm sorry?
There were stop work orders that were ignored? Is that what you're...
There were 16 stop orders.
So you rely on that they were ignored?
Were they on notice that there was potential damage to your particular building?
Judge Graffio, not only were they on notice, but the summonses specifically referred to the danger to our building by the continued excavation in violation of the stop orders.
If you didn't have the orders, would you still have vandalism?
Absolutely.
Why?
Because they were on notice. There was a TRO issued by a Supreme Court judge in Brooklyn that they violated.
Okay, I guess what I'm really saying is if you have these people, you have documents, you have a TRO, you have a stop work orders, you have notices of violation. Suppose all you have is you have they're on notice. You've told them stop doing it. They keep doing it. Is that enough to be vandalism?
I do believe it is, Judge Smith, because the notice that they have, whether it was from my lady or the stop orders or any other outside source, put them in a position where they knew that the result of their
every excavation case can be within vandalism coverage.
If it's in continued disregard with illegal conduct, absolutely.
What about if they didn't warrant on notice? They're doing it, they were just oblivious to what would happen to your property. Would that be okay under the policy?
Judge Lippman, you're tempting me with the Fanberg decision.
Go ahead. Don't be tempted. Go for it.
If they were not on notice, it would be a completely different story because you'd have to determine whether the conduct was intentional, meaning whether there was any ill will towards the adjacent property owner.
There was no ill will towards you, but they could care less what happened to your property. I would assume that anyone who's doing excavation in that kind of a situation might guess that this had the possibility of damaging properties that were adjacent.
Judge Lippman.
Explain to us where it kicks in. Is that once there's a notice, a lot of notice? Could it be no notice if you're oblivious to the consequences? Where do you draw the lines here? Where I think Judge Smith might have been going is how much do we expose, what exposure are in these policies for the insurer? In other words, is any kind of excavation basically, you know, if it's damaged, you're going to be liable? Where do you draw the line? Do you have to have notice? What kind of notice? Or can you just be, again, oblivious, not could care less, but had no particular ill will towards you, doesn't even know who you are, other than that they are or should be aware that if they're doing this, there could be consequences. What are the different gradations
Judge
of this?
Lippman, you're from one extreme to the other.
Yes.
If there's no notice,
Yes.
then you can't turn around and say any excavation that causes damage would fall within a V&MM clause.
So if there's no notice, but you knew that other people could be damaged, okay, right?
If the conduct was otherwise legal,
Assuming it was otherwise legal, okay. What's the next step? What gets you to the point where it is covered on vandalism under the policy? One notice?
one notice
Yeah.
with the expectation that damage could possibly be caused,
Foreseeable? Foreseeable that?
absolutely foreseeable, and unlawful conduct.
Well, so why doesn't every excavation case then potentially fall under one of these policy provisions, a peril of this sort?
Because not every excavation is illegal, Judge Piggott.
Judge Reed, yes.
Well, that's,
sorry.
okay, well, let's say this is an illegal excavation, then it would fall under, you're saying that's the key thing?
Not necessarily, because one of the cases that we had come across in our research was one where they didn't secure a proper building permit, and the notice was there, but they said it wasn't enough.
Well, it occurs to me, I guess, that this is not the kind of thing we usually think of as vandalism. And let me follow that up with asking you, this is a perils policy, right?
Yes.
Are there other perils that you might have gotten insurance for that would more closely, or that would more easily fall within, I mean, what about collapse or something
Yes,
of that sort?
you could have an all-risk policy. This was a named perils policy.
Well, are there any other named perils into which this more clearly falls? Or if I'm in your situation, is this the kind of peril I have to get in the policy in order to recover? There's nothing closer?
You could get a more broader form policy that would cover any kind of
So
damage.
suppose you're sitting around worrying that there might be an excavation next door and it might damage your building. What kind of insurance policy would you be well advised to get?
All risk. All risk.
And your client didn't get that.
She did not. She had a
She would have
name.
had to pay a higher premium to get that.
The premium would probably be 10 times what she paid.
Why should she get the same coverage for 1/10 the premium?
Because if it's a named peril for which she did pay the premium, she's entitled to recover.
Well, I guess that's the question.
And is it the two things, I gather from what you're saying, are notice and illegality? Those must be there?
That's for the state of
You are-
mind.
yeah.
That's for the state of mind portion of what was certified to you from the Second Circuit.
What about proximity? I mean, do you agree with the Sixth Circuit case where it was 3 miles away? Is there, I'm concerned with distance and,
Judge Graffio, that's the case we're relying on all fours, the Louisville case.
right, so.
That was 3 miles
So
upriver.
proximity's not an element of what you're suggesting to
No,
us?
if the damage is a natural consequence of the illegal conduct, it's a covered peril under the V&MM clause. So
Was there notice in the Louisville case?
there was illegal conduct in the
Yes,
Louisville
the
case.
dumping of the,
And they went
toxins.
further and said the natural flow of the water into which the toxic substances were placed would naturally
you
end
need
up at the sewage
illegal
plant.
conduct or notice.
That's
I'm just
correct.
trying to
That's
tick
correct.
off all the elements that you
Even
think
if
are
you didn't-
necessary.
Even if you didn't get the broadest policy, and your kind of policy, if you have those two factors, that's it?
That's it for the state of mind, Judge Lippman.
Right.
Then you still have the other question about the damage being inflicted directly upon the property, which is what the lower court in the Eastern District
Right.
dismissed us on. And I think she was sorely mistaken. I think she just either disregarded the Louisville case or misinterpreted it, because the
But
policy...
Maybe it's just that her reaction, as Judge Reed said a few minutes ago, when you describe these facts and then you ask yourself the question, is this vandalism? The word doesn't seem to fit. Why not? What's the problem that's hanging us up here?
It's, Judge Smith, it's vandalism and malicious mischief. They go hand in hand. It's the inappropriate conduct that constitutes the...
But there's a lot of inappropriate conduct in the world, and vandalism is used only for a subset of that conduct.
Yeah, but it has to be combined with...
This doesn't, to me, this doesn't resemble the vandals sacking Rome, or the teenagers across the street vandalizing my house. Why is it really like that?
I hesitated to do this because I didn't think it would be appropriate for this court. But one of the associates in my office...
A picture of the sack of Rome?
No, told me, this is what I should be flashing before the judges in the Court of Appeals. That was the attitude that was manifested by the excavator
Okay,
and the adjacent owner.
Is every reckless damage to property vandalism?
If there's notice, if
Well,
there's
you-
illegal
it
conduct,
could hardly be reckless without some kind of notice.
if there was notice and it was illegal conduct, you bet your bottom dollar, Judge Smith.
So I don't need, so maybe I should save my money and not buy a property damage policy, just buy a named perils policy and put everything under vandalism.
That's correct, and that's what people do, because otherwise you could have a runaway expense for insurance coverage.
Also in your case, the next door neighbor, these excavators, they ended up paying for the privilege of damaging your client's property. Is that not correct? I mean, didn't they pay a certain amount of these fines? It's almost like the cost of doing business. I just have to pay that. I can keep excavating.
Obviously, you picked up that point in my brief, Judge Rivera. It was an economic...
I read them now and then, yeah.
It was an economic decision. And you turn around and say...
Mr.
what-
Dweck, because it was an economic decision and basically a calculated risk, why is that, going to your second point about the state of mind, why is that intent?
Because if they engage in conduct that is in...
To directly damage your client's property?
They didn't care. They only were concerned about getting their work done, getting their workers to finish the
Exactly.
job.
So they weren't intending to damage your client's property, they were only concerned about getting the work done on their property.
That's correct.
And the damage to your property was just an
It was
unfortunate
collateral,
consequence.
essentially.
It was incidental to their conduct,
Yeah, that's the question, though. So how does that go to intent?
because if they turn around and say, we don't give a damn, and they do things on a reckless basis, they pleaded guilty to 16 summonses.
But wait a second. I think what you're saying, let me understand your argument, it's because they were on notice that this would damage you. Not just, I don't give a damn, and people say, oh, this could hurt people. Did the notices indicate, the different forms, that this would hurt your property in particular, and is that necessary?
Absolutely, Judge Lippman, and it's in the summonses
But
that are
is
published in the record.
Is that another element that's necessary? In other words, it's not just, and I want to understand what your argument is, I don't give a damn. It's, I don't give a damn about you.
I don't give a
Isn't-
damn
is that-
about you or anybody else.
Yeah, but it's the you, isn't that important? Doesn't it matter that they had in front of them, oh, this would damage your particular property?
That's correct. Absolutely correct, Judge Lippman. And since they were on notice that our property would be damaged, and they continued to disregard the summonses anyway, pleading guilty is the equivalent of intentional conduct. If you're pleading guilty, you have intentional conduct, then you have the state of mind that was referred to you for
So
determination
that
by the
makes
Second
it,
Circuit.
that makes it, and are you arguing this? That makes it intent as to you.
That's
Is
correct.
that what you're saying?
Yeah, and we're the only ones here looking to have coverage from my dear friend, Mr. Viviniotis. The other issue that I know you have before you is whether the damage has to be inflicted directly to our property. And I suggest to you that the wording of the policy does not limit, as the lower court in the Eastern District ruled, that the damage has to be inflicted directly to our property. It could be from any source. If the damage is sustained as a result of illegal conduct, it
And
covers our property.
And what's your best cases that you rely on?
Louisville.
Okay.
Louisville is a Sixth Circuit case. You have the King case.
What
You have
about
the Troutwine case.
What about the Second Department case?
You mean Crest Hill?
Yeah.
No notice in Crest Hill.
But Crest Hill went your way, didn't it?
Crest Hill went our way, and the intentional act of severing the pipes.
And it wasn't your clients. It wasn't the insured's pipes that were severed.
It was in the same building, Judge Smith.
I'm trying to argue your side. Why are you arguing the other guy? That's a case of an act on somebody else's property, but which nevertheless was held to be vandalism, as to which the insured could collect for.
My recollection in reading Crest Hill was it was held that the pipes were severed in the same building where the damage occurred.
So you think that distinguishes Crest Hill from this case?
That does.
Why you want to distinguish it? It went your way. Okay.
Okay.
It's favorable to us.
Thanks, counsel.
Thank
We're
you
gonna
very
hear from
much.
Your adversary.
May it please the court, my name is Stephen Verveniotis. I represent Penn Star Insurance Company in this case.
Counsel, what about it? If you have notice as to this particular business, you have illegality, why shouldn't you be held on the vandalism clause? Why shouldn't you be held liable? How much more do you need to have before they can collect from you?
I have a two-part answer.
Yes,
First of
give
all,
it to us.
As to this specific case, I know
Yes.
you've heard a lot about 16 violations, but if you go and look at the violations, they run over a period of 5 years. They include things such as not having the proper plans in place.
Couldn't a jury find that these people were willful?
Not with respect to the other property. What they pled guilty was several violations, including not having plans, not having handrails, not having all kinds of stuff.
They were never on notice that there was a threat to the property next door?
They were told to stop work. They were given certain conditions, if you look at the violations, under which they could continue
but that's
work.
not what the judge asked you. Were you on notice as to them?
There came a point in 2008 in which there was indication about stopping work completely.
Is there a point at which this excavator's conduct could be called willful?
I don't think so, not with respect to the other building, Your Honor. The conduct here, in order to be malice, and the issue that we were all going at before and we were talking about it is, your conduct has to not be a legitimate purpose that has a consequence that can be expected. Much of the case law in insurance drives on...
But if you, I understand that you're committed to getting your job done. But if you know, if you're on notice, that you're performing A, an illegal act, and B, that it will hurt them, why shouldn't you be held responsible?
Because that's
that's not a rhetorical question. What is the rationale under the law or under policy as to why they aren't able to view this as willful to them?
The rationale is that it's not malice intended towards the other building. You may be violating the law.
But why isn't it you know that if you're on notice that it's going to hurt them?
Well,
why isn't it willful as to them?
You may be negligent. There might be circumstances as to a variety of things happening, but the case law from this court has always been that there's a division between the possibility that things could happen and driving something intentional.
You're not saying that the excavator couldn't be liable to the lady who owned the house.
Of course not.
And in fact, maybe she could even be liable for punitive damages?
I don't know about punitive damages.
If she could, or I'm sorry, if they could be liable to her for punitive damages, would that make it vandalism? Would that cause your policy to kick in?
I think punitive damages and vandalism are two different things, and that's what I'm trying to drive at.
Give me an example of conduct that damages property and is so willful and wanton that it would give rise to punitive damages, but it's not vandalism.
I think vandalism is not acting in accordance with how a reasonable purpose would be to be somebody that's totally, as you heard, disregarding the consequences. That's not what vandalism is. Vandalism requires your purpose to be to damage this building. All the cases that we've read.
Suppose kids in the neighborhood don't like my neighbor, and they start throwing bricks at his window, and they miss and hit my window, or some debris flies and damages my house. Have I suffered damage from vandalism?
I don't know. That's an interesting question. I would say not under those circumstances, but I'm guessing with that hypothetical. That drives to the point of what I'm trying to say. If the intent was not to damage your building, but it's a risk that they took, they were negligent towards that,
Yeah, but in ordinary
and that
speech,
happened.
in the hypothetical I gave you, I'd wake up the next morning and say my house has been vandalized, wouldn't I?
You may well say
But
that.
on the other hand, I can't quite see the lady who owned this, this building with the cracks in it. I understand she was very upset. I wouldn't think the first words that would come to her lips would be, my house has just been vandalized. And I'm trying to come to grips with why.
Indeed, that's what I'm trying to say in terms of explaining about the history of this damage. When you look at the record of this, you see engineers' reports that talk about over a period of 3 years. This is something that develops.
If you got a notice that said, if you keep doing this, they are going to be damaged in the following fashion. If you have that notice, is that vandalism? If you know specifically, if you keep doing it, and this is what's going to happen, that could be willful, that would have you responsible under the vandalism clause, or not?
I think not, Your
Why
Honor,
not?
because
Why not?
it's not what you're giving notice of, it's what your intent is. Vandalism...
How could you have any other intent if you have notice? If you keep doing it, it's going to, I mean, as long as your intent is, well, you know what? This is going to help me, so I don't care what happens to them. That's not intent?
No, Your Honor, that's not what I'm saying.
Why isn't it intent if you say, I need to finish this, I just got to get this garage done, I don't care what happens to them, I'm going to finish it, let whatever happens, happens. Why is that not willful intent as to them that would make you liable?
Because the willful and malicious conduct has to be intended towards the other building. It cannot be something that's a consequence of what you did. That's the sticking point.
So you mean, say for instance, an adjacent building that your client, a hypothetical client owns, okay? And they torch the building for whatever reason. They want the insurance proceeds or something. They start a fire. They intentionally start a fire. And that fire spreads to the neighbor next door. You're not going to cover that under the fire provision of this peril policy? Because they only intended to burn their building, not the building next door?
I don't think that's analogous, Your Honor. I mean, I don't know what the answer would be under the fire coverage with respect to that scenario.
Well, it ought to be similar, shouldn't it?
No, it's different because vandalism is different than other
If it's a wanton
conduct.
disregard of the rights of another party, shouldn't that be covered?
But that's not vandalism and malicious and willful directed towards the property, which is what the full wording of the policy says.
Well, so, I think in part you're arguing that the purpose is to excavate, it's not to damage their property. Okay, so, but you have different ways of excavating, and if you choose to excavate in a way that you know in advance will cause that destruction, why is that not going to come within the policy's coverage? I have several choices. I pick the one that I know is going to have a particular outcome that's adverse to this adjacent property.
First of all, clearly that did not happen here. If you go and look back at the record, the excavation...
Let's assume it did.
Happened between 2005, right. So, assuming it did, the fact that there's different ways to excavate, again brings you back to the point that this excavator's purpose wasn't to be maliciously damaging this building next door. Vandalism is truly different than negligence.
Well, maybe it wasn't the
What would you call
primary
it? Would you
purpose,
call
but
it
it's the
gross
obvious.
negligence or
Even the most gross negligence is not vandalism because it's not...
Suppose a kid digs a hole in your front yard because he likes to dig holes, and he knows it might cause your building to cave in, but he doesn't care. He doesn't have anything against you. He just likes to dig holes, and your building caves in. Vandalism?
I honestly don't know. I don't know what that,
Counselor, what is a hypothetical that would be vandalism under this policy, assuming you're excavating, they have the building next door? Give us a hypothetical where it would come under the policy. You're doing excavation, they're being damaged. When is it that you would have to pay?
I don't think excavation, especially under
Oh,
this...
so it would never be
I don't think under this policy would be this, even specifically in this policy provision that says we're not covering anything
So it
that has...
can never be excavation because why?
Because excavation is not vandalism. The words have to be given the meaning that they have.
So they should have had-
Vandalism
they should
means
have-
that you intend to willfully damage this property.
So in order to recover, they had to have an all-risk policy?
They would have to have an all-risk policy, yes, instead of this
You
policy,
say
which they paid
excavation, you say
$3,000
excavation's
for.
not vandalism, but you could imagine that digging holes might be vandalism.
Digging holes, especially on your property, that goes underneath, I guess, the foundation of your property, if I take the hypothetical to,
Yeah,
I guess, its
okay.
logical consequences, would be something where you're actually doing something to the property.
Okay, but I mean,
So
I guess what I'm
it's
really
much
saying is,
closer.
isn't excavation a word that means digging a hole?
Except, Your Honor, the excavation and all the work happened on another property.
So if the kid who likes to dig a hole dug it in your neighbor's lawn and it undermined your house, then you have not suffered any damage from vandalism.
I don't think under that scenario that that kid is any different than an excavator who's doing something on somebody else's property. They're not, although they may be negligent and they may have proximately caused under some scenario, I don't, you know, the kid as well as the contract may have caused the damage.
What if, again, on a hypothetical, what if the person was trying to knock down their house but knew that it was going to knock down the neighbor's house as well? Would that be vandalism?
Again, Your Honor, I don't think that's vandalism. The fact that there may be some consequences to your actions, and you may be negligent in how you go about doing your actions such that those consequences occur,
What if the person
doesn't
had a
mean-
grudge, what if the person had a grudge against the neighbor and instead of just harming the neighbor, decided, well, I'll just, knock down my house and knock their house down too?
I guess that could be relevant in that analysis, because if the person's intent was to damage the building next door, I guess, and that was their vehicle for damaging
So you're
next
saying
door.
it's different because they didn't intend to,
No, clearly, when you have a legitimate
You're
purpose.
saying the difference is that your argument is as long as primarily you're doing it for your purpose, even if you don't give a damn, even if you know it will hurt them, it doesn't matter. So the difference in intent between what Judge Abdus Salam just said to you and what you believe is the general law, that as long as you have a reason for what you're doing, even if you know it's going to hurt the other building, you've been told, you're on notice about it, and you say, the hell with that, I don't care. That's okay, as long as you have a purpose, illegal or legal, that you're performing, that's okay, that's not vandalism.
My focus, Your
Is
Honor...
that your argument?
My focus,
Is,
I think so, but I just want to be clear.
no, but in my words, answer my hypothetical. You, as long as you're building a garage underground or whatever you're doing there, you know it's going to hurt them, you're on notice it's going to hurt them, it's illegal what you're doing, as long as your mindset is, I don't give a flying, you know what, I want to finish this garage, no coverage, no vandalism.
I think that's not vandalism, and indeed...
What
the
is it?
question-
What is it?
I think it may be negligence. You can sue them and you can prove your damages, which is what they're doing. But the question that's been certified to this court asks you to understand that
It's
there's
not,
nothing
it's
that...
not willful and malicious damage to property?
No. The certified question is an act not directed specifically at the covered property.
And what's your best case for your property? What's your best case, other than the district court in this case?
The Fanberg case, which is on page 25, and then a series of other cases.
Do you have a sense of what happened? I mean, you don't learn much about the facts from reading the Fanberg opinion.
I think it's pretty analogous. I don't think playing around with whether you had a violation notice or not getting a permit, you know it's illegal. Everybody knows what the consequences are when you do excavation, especially in the city, and you got building next to building touching each other.
Was the court in Vandenberg saying it's not vandalism, or were they saying it wasn't, they didn't intend to do it? The second question, were they answering the first question that we've been certified?
I think it's the first question because clearly it's the same type of coverage, and they said this isn't vandalism coverage, this is construction next door.
But in Vandenberg, didn't the second department cite favorably the Crest Hill case where they said it was vandalism when someone ripped out pipes and?
The Crest Hill is totally different. The consequence of running the water is in the same building for the water to flow downward. You are directing something at the building. And again, I come to the question, back to the question that's been certified.
Why is flowing water onto somebody's property so different from digging a hole next to his property when you know he's going to undermine his foundation?
Because the coverage for vandalism depends upon you doing something to the property.
Well, they did do something to the property. The problem is that it wasn't directed at the property. That the guys in Crest Hill didn't care about the people. They may not even have known there was stuff downstairs. They were just tearing off pipes.
But that's the wording of the coverage. It has to be directed to the property.
If Crest Hill was a condominium, so there were 2 units, different title owners, would there be coverage?
I think it was 2 different owners of 2 different units, but in the same building.
I thought they were tenants, but maybe I'm wrong.
No, it was 2 different ownerships and
it's
2
just
different
in one
policies
building?
involved. It was in the same building.
Because it's the same building, you've got better coverage if you're another
No,
unit in the
because
same building instead of being, say, 2 single-family houses 20 feet apart?
The water going onto that property is something directed at that property. In this case, there's nothing that was directed.
Isn't that an awful fine distinction that you're making, that if it goes here, it's okay, but if it goes here, it's not?
But, Your Honor, it has to be a fine distinction in this situation. The limited coverage that's purchased for a very low price here has to be only for vandalism coverage, for somebody coming and damaging your building directly, not consequences that impact your building.
But I think the issue is what is damaging your property directly. Is it if it flows downward or if it flows across? Are those 2 different situations?
Nothing flows across when you excavate.
If you excavate and the other thing collapses, obviously something's happening to the other property.
But you're not doing it to the property. You're doing something in order to do construction work that the other property then succumbs to. There's a difference. Vandalism requires you not to do things that there could be consequences to another building, but to do something to the building.
Okay, counsel. Thanks. Thank you both. Appreciate it.
Thank you, Your Honor.
Thank you.
157, Sandiford.